Supreme Court in Washington, D.C., the lawyers will all be convening. Each lawyer representing the 27 states of the Union that have filed suit against the federal government, Kathleen Sebelius, to invalidate this law because it is unconstitutional. It violates the Commerce Clause of the U.S. Constitution. I mention that because the reason I got into this book is when that bill, the Health Care Reform Act bill, was pending in Congress, and you remember it was not a pretty picture the way they shoved that thing through Congress. Remember the corn husker, the Nebraska corn husker kickback and all that business? That, if you have short memories, that'll remind you how nasty it was. The whole process was nasty. It was like watching someone make sausage, as they say. But anyway, it got through, as you know, it was shoved down our throats. And when Miss Pelosi stood up, remember that in the news media 2 years ago, March 25th, she says, well, now we've passed the law, she says. It's 2,000 pages long, she says, and of course no one knows what was in the law. She says, but now we'll find out what's in it. Remember those famous words, okay? And those words have come back to haunt her ever since. Well, okay. Well, Dean Chemerinsky from Stanford University Law School in California. I'm living in Pittsburgh, east of Pittsburgh. And so I pick up the Pittsburgh Gazette, which is the paper I read. And the Pittsburgh Gazette, you have to understand, it's like the Boston Globe, New York Times, Washington Post, Chicago Tribune. So that tells you. All right, Pittsburgh Gazette has a full article from this Dean Chemerinsky, the dean of the law school at Stanford University in California. And his whole article was, if anyone is even thinking about challenging Obamacare under the U.S. Constitution, forget about it. Don't even think about it. You're going to lose, he says. You're going to lose. And then he, as a law scholar, it explains in his article why he thinks it would be even silly to even think about, to contemplate a constitutional challenge of this law. Because he mentions a case that the Supreme Court handed down, and indeed they did, in 2005, the medicinal marijuana case out in California again, known as the Angel Rach case. Angel was a lady who she had medical problems. She had medicinal marijuana, which is legal in the state of California. So she has it. So here comes the Federal Drug Enforcement Bureau, and under the federal law called the Controlled Substance Act, a federal law, you know, from act of Congress, okay, makes the possession of even lawful medicinal marijuana that Angel Rach had in her backyard, as she grew in her backyard, a federal crime, okay? So when her lawyers in the Rach case got to the Supreme Court, they said, this is a violation of the Commerce Clause of the Constitution. And I'll just stop for a second. The Commerce Clause is one of the 4 key clauses that I propose that we must amend. We must, by curative amendment, restore the original meaning of it. And that's part of my action here for a constitutional convention. And yes, the new book will be called Convention. Why? A constitutional convention to amend 4 clauses of the Constitution. The Commerce Clause is one of them. All right, when the Supreme Court got Angel Rach's medicinal marijuana case, they said, oh, yeah, this may not be technically commerce in the sense of the meaning as it is in the Constitution, but by her having this backyard-grown marijuana, it may possibly, theoretically, affect the interstate trade of marijuana, you know? And so the lawyers up there representing her are saying, how can that possibly be? That is ridiculous. We can say that about anything. Anything you do here locally, even in your own backyard, could possibly affect, that's the key word, affect interstate commerce. And believe it or not, ladies and gentlemen, that is the law of the land today in the United States of America. Did you know that? That's why the Constitution, as I charge, has been corrupted. It has been bastardized, it has been distorted, it has been expanded to go far beyond the original meaning of it, because the Supreme Court of the United States, of course with the blessings of the President, blessings of the U.S. Congress, have passed these laws that really invade local personal activity that has no business being controlled or regulated at the national, federal level. in central headquarters in Washington, D.C. So when I read Dean Chemerinsky's article, it actually enraged me a little bit. I said, how dare this Professor Chemerinsky, by the way, he was the lawyer that argued the case that the Ten Commandments should have been taken off the courthouse grounds in Texas. Remember, he lost that case, by the way. That's the Perry case. He lost that in Supreme Court. But that's the same guy who wrote this article. So I read it. I said, somebody's got to respond to this guy, okay? So I wrote a beautiful, long, lengthy, somewhat scholarly letter to the Pittsburgh Gazette, letter to the editor. How dare this guy, Chemerinsky, say this day? Well, they never printed my letter. I got a note that your letter is too long. You're limited to 25 words. Yeah, right. Anyway, so I said, you know what I'm going to do? I'm going to write a book. And I'm going to write a book. Yeah, that's the reason for this. And I said, I'm going to write a book. But not only am I going to talk about the Congress, but I'm going to talk about the whole U.S. Constitution from the beginning of time, from 1787 on, the Founding Fathers, the great Founding Fathers, the 55 men that appeared at the Philadelphia Convention Hall in 1787, the month of May. They stayed there for 4 long, hot summer months with the windows shut, by the way, and the doors locked, because they had to maintain the secrecy of the proceedings. And those 55 men, you know, George Washington was the presiding officer, okay, and James Madison, the father of the Constitution, who I talk about over and over again here, and Alexander Hamilton, who they call the godfather of the U.S. Constitution, and that's the truth, those two guys. And all the rest of them, George Mason, Rutledge, Edmund Randolph, and on. Great, brilliant, Thomas Jefferson, no, he was in Paris. Brilliant minds, okay? And they contrived and put together the United States Constitution, which is a unique document. And I start my new book, Convention. I just pulled this one page out of the introduction. It says there, America's DNA is the U.S. Constitution. America's character and karma is the U.S. Constitution. Okay, among the nations of the world, we are a special kind of country because of the U.S. Constitution. And if you remove the Constitution's protective cloak from around our shoulders, you know what happens to us? It transforms us into a different people, a different social order, a different kind of America. And that's the threat we face today. I says today our Constitution has 1 foot in the grave, okay? It has 1 foot in the grave. And my new book, Convention, has a subtitle, To Resurrect the United States Constitution. What do I want to do? I want a Constitutional Convention for the second time in U.S. history, as in we haven't had one 230 years. I want a second U.S. Constitutional Convention, okay, where all 50 states will send delegates to a venue, place wherever we have the venue for a Constitutional Convention. Second time in our history, okay? And what are we going to propose? We're going to propose to amend the Commerce Clause, a curative amendment. And I have in my website actually proposed how that clause may be reworded in such a way that laws like Obamacare will never see the light of day, okay? A lot of these cap and trade regulations never see the light of day because they violate the Commerce Clause. Federal government has no business in this area. In Pennsylvania, we're drilling right now for they call it fracking, for natural gas, okay? The Marcellus Shale, Pennsylvania. I was talking to one of the gentlemen here a minute ago, which is proof of the pudding how states can take care of their own business. The Commonwealth of Pennsylvania monitors, regulates, controls natural gas drilling better, 10 times better than the EPA could ever, Lisa Jackson could ever dream of doing, okay? It's a perfect example. Okay, so what I'm saying here is by restoring the original meaning of the Commerce Clause, we give power back to the states of the Union. And I'm going to keep this sweet, short, and simple because then I'm going to open it up to questions because you got to get back to work. We give the power back to the state, and that's the way the Founding Fathers designed our U.S. Constitution. But the Supreme Court, beginning with that Angel Rach medicinal marijuana case, they started corrupting the Commerce Clause. It actually started years before, but we don't have time for that kind of history. But they actually corrupted the Commerce Clause, Supreme Court. And Congress, look what they've done here now with Obamacare. So now here's what I'm going to tell you. 1 week from now, the lawyers are going to convene up there in Washington, and unprecedented, they've allotted 5 hours for oral argument for the attorneys. Usually it's 1 hour. Now, watch this lawyer is going to represent Florida. His name is Michael Carvin. Okay, I've seen him. I've seen him in action. There's another guy who's senior above him, Paul Thibodeau, whatever his name is, that he's been arguing in so many cases with the Supreme Court, but in my opinion, doesn't hold a candle to this guy, Michael Carvin. Guy is an old guy, heavy-set guy, balding with long hair. He reminds me of William Jennings Bryan. Looks just like William Jennings Bryan when he argued with Scopes' monkey trial against Clarence Darrow in the 1920s. This guy looks just like him. But what a brilliant man. I've seen him in action, okay? He's going to be arguing next week in Washington. Michael Carvin, one of the lawyers representing Florida. It won't be Pam Bondi. He'll be arguing that this health care law violates, Your Honors, the Commerce Clause, because an insurance mandate that mandates you to buy a health insurance policy is not, by any stretch, commerce, okay? Commerce has a very concrete meaning. It means trade and exchange of articles, commodities, goods, buying and selling. That's what the definition of commerce is, okay? And an insurance policy doesn't fit that definition. And it really doesn't. See? But more than that, to force this lady to buy a product she doesn't want to buy it. She's healthy as can be. What does she want to buy a health insurance policy for, you know? And pay it. You know what? She doesn't want to do it. You don't want to do it, okay? For whatever reason. But the federal government, our USA of America, the land of freedom, and liberty, is going to come in and say, you must buy this product. Okay, that's the mandate, the individual mandate. They're going to say, that goes far, far beyond, in an unprecedented fashion, anything that the Commerce Clause has ever been interpreted to include or mean. And that's what Michael Carvin, the lawyer that I told you about, you just watch it. This is what he's going to be arguing, okay? Now, here's what I'm going to tell you. The three ladies on the Supreme Court, Elena Kagan, Sotomayor, and Ruth Ginsburg, and the other gentleman, Stephen Breyer, that's the four of them. Very, very, very liberal, very much over here to the left, okay? They're going to vote to uphold Obamacare, okay? Now let's talk about the other guys. We got Roberts, we've got Sam Alito, we've got Antonin Scalia, and last but not least, we got Clarence Thomas, the greatest. And then we have the swing vote that we don't know how he's going to go, because sometimes he votes conservative, sometimes he votes liberal. You just never know. And that is Justice Kennedy, the swing vote. Okay, so in my book, the new book, I say to people, I said this 7 months ago, and I posted this essay on my website. 6 months ago I posted this website. I says, you know, everyone assumes, all the newspaper pundits and the TV pundits and everybody, all this Megyn Kelly on Fox News, they all assume, Judge Napolitano, they all assume that Kennedy is going to be the swing vote. And I says, not so fast. You know who may be the swing vote? I hope you're sitting in your seat here ready for this one, okay? The guy, one of the staunchest, most brilliant of the nine, guy, conservative on that court, is probably and maybe going to be the swing vote here. And his name is Antonin Scalia. No. Oh yeah, you watch. Now I'm saying this to you now because you people are going to be privileged to go on C-SPAN 1 week from today at home while you're sitting in your living room and hear the oral argument. You won't be able to see it, no TV in the Supreme Court. But you can hear the audio. And you just listen to the lawyers representing Obama and the government. And you know what they're going to argue? Justice Scalia, you, sir, in the Angel Ranch medicinal marijuana case in California in 2005. Do you remember that case, Justice Scalia? Yes, I do. I wrote an opinion. Yes, you did, sir. And in that case, you sided with the federal government on that Controlled Substance Act and said that Miss Ranch could not grow medicinal marijuana in her backyard. And you know why you did it? You didn't do it under the Commerce Clause. You did it, you proceeded through the gates of the Necessary and Proper Clause. That's the second clause that I want to amend with my Constitutional Convention. And on my website, I propose the rewording of the Necessary and Proper Clause, because it's a dangerous clause. And it is the last refuge for all the liberals and progressives like Pelosi's and the Reeds, et cetera, in Washington, D.C., that they can't find justification for these ridiculous federal laws under the